Hi, everyone. Thanks for attending the St. Mary's County Library presentation, The Bill of Rights. So, this is part of a series about the creation of the U.S. Constitution. It is the final presentation in the series, and our speaker is Dr. Jim Gibb. He'll be talking about, of course, the Bill of Rights, which are about our individual rights and liberties as Americans. Really quickly, my name is Allison. I'm a librarian for the St. Mary's County Library System. I'll be facilitating tonight's presentation. All right. Jim, would you be able to talk about your background really quickly?
Sure. My name's Jim Gibb. I've been an archaeologist for 50 years, not a political historian or a historian in general. So when I talk to folks about the Constitution, as has been the case all along, I do so as somebody with an inquiring mind, but not actually trained in this particular area. Um, so I don't know what else there is to say about me. I went to school at University of New York, University, Stony Brook, and Binghamton for all 3 degrees. And I'm a product of public school education in the state of New York. So, uh, with all that, I guess I'll go ahead and share screen. Okay. So, per usual, I like to start with a quote. Um, and this is from a very famous jurist. He never served on a Supreme Court. But I thought he was always considered a very wise judge, so I thought it was worth sharing this. That community is already in the process of dissolution where each man begins to eye his neighbor as a possible enemy. This is during the McCarthy era, where nonconformity with the accepted creed, political as well as religious, is a mark of disaffection, where denunciation without specification or backing takes the place of evidence, where orthodoxy chokes freedom of dissent, where faith in the eventual supremacy of reason has become so timid that we dare not enter our convictions in the open lists to win or lose. Again, this is something he wrote during as a speech before the New York University Regents during the middle of the McCarthy era, and I think it's as valid today as it was then. So today I want to talking about the Bill of Rights, but I also want to talk about interpretation and specifically two theories of interpretation that we hear about on the news from time to time. Uh, and I'm actually going to apply these theories to one of the Second Amendment, actually, not because my opinion on the Second Amendment carries any more weight than anybody else's, but just to show you how you can come up with a very different interpretation using uh, the same guidelines. And so we'll get to that in a few moments. But again, this is the last in this series on the U.S. Constitution. We're going to take a break over the summer, start again in September. I expect to be back to talking about archaeology, unless somebody has some ideas about a new series we might try out. Anyway, I thought it important to make this point here because although I've modified this talk over the last several months, I initially prepared it on January 24th while watching events in Minneapolis unfold. So, I mean, that's got to color my perspective a little bit. So, just a heads up. So, let's start off with some theories of interpretation. These apply not just to the Bill of Rights, but to the entire Constitution. And as you'll see, apply to statute law as well. There are two theories we hear about on television all the time, particularly in regards to the Supreme Court. The one is textualism, and the other is originalism. And I have here my definition anyway. What do the specific words of the law say apart from any other consideration, such as intent of the legislators in writing and enacting the bill? And what does the text reasonably mean? And the phrase you'll often hear from practicing attorneys is it's what is in the four corners of the page? What does the law say in plain English? Not interested in what the intentions of the legislators were who passed that law. And this has been kind of the rule at the Supreme Court level, certainly for the last couple of decades. And it's a little weird because some laws tell you up front in a preamble what the intent of the legislature was. In any case, textualism, what do the actual words say, is something that's usually applied to statute law. That is, laws that start out as bills in Congress or signed by the president and become law. Originalism is a theory wherein we're trying to get at how did people at the time the law was written, in this case, Constitution and various bills of rights, how did they understand what was written? How did they understand the words and phrases? And originalism is generally applied to the Constitution rather than to statute law. But you will see both of these discussed constantly with Supreme Court decisions, at least certainly major Supreme Court decisions. And the court, as now constituted, has a very strong emphasis on these two theories of interpreting the Constitution. Uh, the late Justice Anthony Scalia was a big proponent of originalism. So, um, the problem with these theories is they both rely on the ability of jurists to determine past meaning. With textualism, what do the words mean? And with originalism, basically historically, how did people at the time understand these words and phrases? Textualism, I mean, I think I'd probably be a very good textualist because I'm a very demanding editor. I redline stuff all the time, and try to, when I'm working with uh, people submitting articles for publication in journals I've served as an associate editor, um, getting rid of the extra words that don't carry any meaning, uh, suggesting words that seem to me that carry the meaning, what the writer intended, but pick the wrong word. Trying to get through convoluted sentences where you lose clarity. And so to a certain extent, textualism requires the skills of an editor brought to bear. I think Myron Beckenstein is on this call. He could certainly comment on that, having formerly served as an editor for the Baltimore Sun. Originalism requires knowledge of the past, not just historical, but anthropological, uh, about how people saw things and what people are we talking about anyway? Whose understanding are we addressing? Was it just adult white males who met certain property requirements and can vote, or is it their understanding that really matters? What about the other people? And even within that group, isn't there variability? Jurists I've seen, at least since I've been watching the stuff over the last 20 years or so, are terrible historians. Most of them are not well enmeshed in the history of our country. They're lawyers, and I've not seen any of them that's shown any ability, any training in anthropology, which I think is equally important. Both of these approaches run counter to the concept of living constitution. That is a constitution that changes as our society changes. It's sometimes referred to as judicial pragmatism, less ideological, more adaptive to changing conditions. And as we go through some of the bills, some of the first 10 amendments, you'll see where that really makes a difference. So let's look at these amendments in order and think about how some of these theories affect them. There is a preamble to the Bill of Rights. This is 10 amendments that were proposed all at one time. Um, Actually, there were 12 amendments. Two were never ratified. So we're looking at the 10 that were. And it was ratified by Congress on March 4th, 1789. According to the Constitution, that was supposed to be the day the president would be inaugurated. As it happens, George Washington wasn't inaugurated for another 4 weeks or so. But this is kind of the first major act of Congress passing this Bill of Rights. And it says, and I emphasize the second word, conventions, the conventions of a number of the states having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added. That is, people demanding a Bill of Rights, as some states had already adopted for their own state constitutions. Resolved by the Senate and House of Representatives of the United States of America in Congress assembled, two-thirds of both houses concurring, and this is consistent with what's required under the Article 5 of the Constitution, that the following articles be proposed to the legislatures of the several states. And here we're not talking about conventions anymore. It's the legislatures of the states that would ratify or not ratify these amendments. Congress had the option of saying to the conventions of the several states, but decided that they preferred to have the legislatures do it. As amendments to the Constitution of the United States, all or any of which articles, when ratified by three-fourths of the said legislatures, again, this is Article 5 of the Constitution, to be valid to all intents and purposes as part of the said Constitution pursuant to the fifth article of the original Constitution. So the amendments, and we have 27 of them now, are considered part of the Constitution, not just add-ons. They're not less significant. They're uh, uh, just as much a part of the Constitution as the original document. So the implications here are, first of all, it's by conventions within the 13 states, two of them being a little slow to ratify, but the 13 states that ratified the original Constitution. And it was those ratifying conventions that demanded amendments as sort of a condition of ratification. They were going to ratify anyway, but they did so with the understanding that first thing to be considered would be adding amendments that would guarantee certain rights. It required two-thirds of both the House and the Senate. Notice that the President of the United States and the Article 3 branch, the judiciary, have absolutely nothing to do with amending the Constitution. To me, this is one of the strongest cases one could make that the Constitutional Convention and the state ratifying conventions expected that Congress would be the preeminent power in this triad. Because here, yeah, the president has absolutely no part in this at all. The judiciary doesn't. Um, Again, it's the legislatures in this case that ratified the first 10 amendments. Only one of the 27 amendments was actually ratified by state conventions, and that's the one that essentially repealed prohibition. Uh, and again, all these are now considered, these amendments are considered part of fundamental law, the basic law for our country. Okay, who does the Constitution, who did the Constitution apply to? It's really important to understand that the original Constitution applied only to the federal government. It didn't apply to anybody else. It didn't apply to state governments. It didn't apply to local governments. And so I thought I'd throw in an early bit of case study here. That's a case that took place in Baltimore. And here's an argument from a guy named John Barron. Actually, there were two other co-plaintiffs in this, as I recall. And this is just an excerpt from it. For within on year last past, many parts of our wharves, this is on the Patapsco River in Baltimore, have been filled up with sand and dirt from 4 to 6 feet. One of the reasons I like this case is it touches on the whole erosion sedimentation issue that I've been harping on lectures over the past several years. We apprehend and fear that if the city commissioners continue digging ditches to alter the water course, that our wharves will be useless to us and entirely ruined. So this is just a letter. But it's a court case that was initiated against the city of Baltimore. And you can see the area here. It's just pretty much below the pink area, which would have been at the time downtown Baltimore, Fells Point. So it's a series of wharves here that were being affected by sediment that was released into the river by city improvements to waterways, roads, etc. So they brought their case, made their case that these city improvements were damaging their property. And oh, I have a typo in there. Uh, and so they were suing the city saying that our property was being taken without recompense. Our property was being destroyed without due compensation. And this is, uh, basically Fifth Amendment. Uh, the city settled with Barron and his co-plaintiffs for $4,500, which at the time was a lot of money. But the agreement was overturned by the state appellate court and then eventually went to the Supreme Court. And Chief Justice John Marshall, writing the majority opinion, said that the just compensation required under the Fifth Amendment applies only to federal actions. And he's correct in that. The Constitution applied only to federal government and federal actions. To a certain extent, that changed with the passage of the 14th Amendment in 1868, which we hear a lot about because it touches on the ability, well, for instance, I think Citizens United, it allows, corporations to give huge amounts of money and campaign contributions and all that. It all comes back to the 14th Amendment. But with the 14th Amendment, it says specifically that states have to ensure due process and equal protection under the law. And that's a process that's referred to as selective incorporation. So they take these rights that are in the Constitution, particularly in the Bill of Rights, and if they involve equal protection or due process, they are incorporated into the 14th Amendment and therefore then apply to the states and any other government agent level of government. Oops. So here's the part of the 14th Amendment, first section, second sentence. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person, note here it's person, not citizen, of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. If you memorize no other part of the Constitution, memorize this part. Because number one, it says this applies to any person within a state. You don't have to actually be a citizen. And the states have to ensure due process of law and equal protection of the law as per the Fifth Amendment. So anyway, I want to go ahead and let's go through these various amendments. And a point I want to make and perhaps should make repeatedly, the Constitution doesn't prevent the United States government from doing anything. It doesn't prevent state governments from doing anything. The Constitution says this is how things should run. These are our rights as citizens and even as persons who are not citizens. We use the Constitution in the courts to correct government, to tell government, no, you cannot do that. That's one way. The other way, of course, is civil action, getting out on the streets and protesting. That's how we ensure that our rights are observed and that the government does what the Constitution allows it to do. The document itself doesn't stop anybody from doing anything. That's probably true of any law. So, First Amendment, generally referred to as freedom of expression. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So these are guaranteed rights. One might argue, however, that they're not unqualified rights. And this is a major issue in interpreting the Constitution. The general consensus is that there is no such thing as an unqualified right. All of them have limits. So, for instance, free exercise of religion. After we're through here, I can't go out and sacrifice somebody in my backyard as some sort of religious observance. That would be considered illegal, and I'd probably get into trouble for it. Polygamy is generally considered, although it might be part of a religious observance, is something that at the state level, federal government doesn't deal with marriage generally, but the state governments can limit. Freedom of speech. Oh, is it 1910, 1911? Joseph Story, Chief Associate Justice of the Supreme Court, saying you can't yell fire in a crowded movie theater. Your freedom of speech does not extend that far, because in doing so, you can cause extreme harm to people and thereby uh, prevent them from exercising their rights. Freedom of the press. If I had access to the launch codes for U.S. Nuclear arms, could I share them publish them on the internet or in a newspaper? Probably not. In fact, I'd probably get in trouble because why do I have that information to begin with? The right to peaceably assemble creates certain problems because what constitutes peaceably? We've seen recently uh, government trying to crack down on protests that at least initially were peaceful. Uh, um, and by trying to ramp things up, made not peaceable. And who decides what's a peaceful protest and what is not? The right to petition, protesting World War One could have landed you in jail. Um, and protesting the failure to grant women's suffrage, which brings us to this slide here. I have a little note here at the top left-hand corner. If you haven't seen Suffs, do so. This is a musical. It's been broadcast on public broadcasting a week or so ago. It's now accessible through their streaming. It's a wonderful musical. It really gets into the persons and involved in the women's suffrage movement, and it's good music. But in this case, we have several women who were protesting who were sent to prison and force-fed when they went on a hunger strike because they were exercising their First Amendment rights. And this was under the administration of Woodrow Wilson. Most of you, well, I'm sure hardly anybody here remembers this, but the McCarthy era, uh, which generally extends beyond McCarthy's participation in it from pretty much 1947 to probably 1957. And we have Senator Joseph McCarthy, who was accusing people without evidence. Remember uh, the jurist quote I started off with this evening, without any evidence, intimidating people. You've all heard of blacklisting, and especially in Hollywood, State Department. And he was using it to promote himself and didn't care about the damage he was doing. Um, but this is a senator, a United States senator, who is basically preventing people from exercising their constitutional rights. J. Edgar Hoover, longtime director of the FBI, well known for abusing his power, for violating the law in surveilling people. Um, Never got in trouble for it. Harry Truman, a lot of people see him as a big hero. I'm sure he did some great things. I mean, he integrated the armed forces in 1948. But he also issued an executive order that imposed a loyalty oath on all government employees, which one might say is an abridgment of our First Amendment rights. Just because you're a government employee doesn't mean you cannot voice your concerns, your criticisms, as long as you do so clearly as not a government employee, but as an individual. And here's where I'd like to actually apply some of these theories of originalism and textualism. The Second Amendment, which is a really short amendment, a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. So there are a number of questions in researching something like this that you might ask. I mean, why this amendment? You know, why did they think this was important to include among those first, the proposed 12 amendments that ended up being just 10 ratified? And the problem was this is in 1789. The Constitution was written, but not ratified in 1787, so just 2 years earlier. But the events leading up to the writing of the Constitution by the Constitutional Convention, a lot of it had to do with rent riots, about mob action against foreclosures, particularly on farms. And that really rattled a lot of people. It's probably the reason that convention signed off on the Constitution. Southern states particularly were concerned about slave insurrections. They'd been happening for a century, at least for a century, and they needed firearms, they thought, to suppress those insurrections. And of course, conflicts with Native Americans on the frontier.
Jim, we have a
It's
question in the chat.
sure.
It says, what constitutes a well-regulated militia? Who'd be regulating it?
Well, I don't know. It didn't say. They made one sentence with two clauses. There's not a lot of detail there. A reasonable person looking at that might go that, military units, they train, and what they're training in is discipline. So soldiers are trained to a particular discipline, so they operate as a unit. And everybody doesn't go following their own idea about what to do, especially in combat. But in order what they're saying is that a well-regulated militia, you need that to preserve the state, a free state. And again, that's where the rent riots, the slave insurrections, conflicts with Native Americans come in that the state needs to have, according to this theory anyway, a military force, a well-regulated military force to protect the state and its citizens from these sorts of conflicts. I can't do any better than that. I mean, you can write books on this subject, but clearly the first Congress of the United States did not write a book on it. They just gave us this one sentence. Um, a well-regulated militia, security of a free state. This is the only one of the first 10 amendments that starts off with a defining clause. It effectively tells us what the intention of the drafters of this amendment had in mind. They didn't go into a lot of detail, but they're saying, okay, for a well-regulated militia. It talks about the right of the people, but it doesn't tell us who the people are. I mean, is it everybody, or is it just adult white men who hold a franchise?
There is another
Uh,
question in the chat.
sure.
Wasn't one of the reasons for the Second Amendment due to fear of tyranny from a central U.S. government, similar to the tyranny of the British government before the outbreak of war?
Exactly right. And I get to that subsequent slide. I could have stuck it in there too as another example. But yeah, some of the states were particularly concerned that the national government, which would eventually have a standing army, although most people were against that sort of thing, it would have a standing army and be able to impose its will on the individual states. And so the states wanted to feel like they could defend themselves against the national government if it came to that. I'm not a constitutional scholar or political historian, so I don't know how widespread that particular concern was. I only know that it was an issue. It was probably more of an issue at the state ratification, when the legislatures were ratifying these amendments that probably came out. Um, there's also the pragmatic issue of, well, even if the government prohibited people from having bearing arms, what would they do about it? Because at the time, the standing army of the United States was, I don't know, certainly under 1,000 officers and men, covering 13, well, eventually 13 states and expanding into territories. The national government couldn't have prevented people from bearing arms even if they wanted to. They simply didn't have the means to do so. And then finally, and this is really an important issue when not necessarily deciding what the Second Amendment means, but in terms of applying textualism and originalism to the Constitution. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. What's missing from that sentence? I will explain. We have a nice image of a soldier there with an arm and with ammunition. Dr. Samuel Johnson, basically creator of the modern English dictionary, defined arms as weapons of offense or armor of defense. And even nowadays, in modern usage, arms are considered equipment. Ammunition are considered expendable. If you look at period documents from the 18th century to the Revolutionary War and afterwards, in most correspondence and all kinds of documentation, there's always a distinction drawn between arms and ammunition. And the phrase arms and ammunition is often used. The Second Amendment says that Congress cannot write a law that precludes people from bearing arms. It shall not be infringed. It doesn't say anything about ammunition.
And we do have a comment in the chat. Sorry to interrupt again.
No, that's by all
Um,
means.
it says, but the Supreme Court threw out the qualifying clause in its decision.
I'm sorry, I didn't get that.
Oh, it just says, but the Supreme Court threw out the qualifying clause in its decision.
Yeah, that's exactly right. In a recent Supreme Court decision, they, in an unprecedented manner, as far as I can tell, simply eliminated the initial clause. I don't know where the Supreme Court comes off doing that. I mean, it's strange. So the point is, there are a number of issues with the Second Amendment, and I use it as an example because it is so rife with problems. Um, there are things that I think we should consider. There are folks who think that the United States Constitution is a living constitution, that it has to grow, expand, define, address in greater detail uh, issues as they develop, as we as a society develop. So, Congress would not make a law governing unqualified individual right for which they had no means of enforcing. Okay. To me, just initially in the Constitution, the Bill of Rights, Congress would not put something in the Constitution that they couldn't do anything about. So, without the power to actually deprive people of arms, it would have been silly to prevent people from holding arms. And an argument that would have been made by folks like Alexander Hamilton would be that without the Bill of Rights in the original Constitution, there's nothing that gave the national government the power to prevent people from bearing arms anyway. So why do we need a constitutional right? Why bring it up? Government didn't, National government does not have the power under the Constitution. We don't really need to single out an individual, particular right. Another issue at the time. We're not even talking about how the Constitution's developed over the last couple of centuries. The nation was agricultural. That's what we did. We grew things. And the framers, a number of whom were farmers, planters, understood that farmers need firearms to protect crops and livestock. You shoot crows, you shoot foxes and raptors who going after your lives, your uh, uh, yard fowl, etc. So they understood that firearms were just another tool to be used. They understood that there were frontier households that had to deal not only with Native Americans who were hostile, usually for pretty good reason, but also they needed to protect themselves against their fellow Americans, not all of whom were law-abiding on the frontier. Think of the Wild West and, you know, push that back a half century or more to, the Trans-Allegheny area where you've got folks often not even owning the land, just settling on land, and no law to speak of. People needed firearms to protect themselves. Another issue at the time was, with the militias, long before the National Guard was became an official entity, I think 1916. Militiamen were expected to provide their own arms. So if you met certain criteria, you were male, white, presumably, adult, certain age, like 18 to 50 or something like that, you were expected to participate in the militia, to show up on days, court days usually, to train, and you were expected to bring your own firearm. If you were called into action, you were expected to provide your own firearm and whatever ammunition that you may have had on hand to address an emergency. But the reality is, for any kind of long time engagement, if a militia had to be put in the field for a month or two, was actively engaged in conflict, nobody expected the individual militiamen to provide their own ammunition. It was too expensive, too hard to get, and be very difficult if you've got a company of men, with different kinds of firearms, different caliber, having them all out shopping for their own gunpowder and ball would have been unmanageable. So these are some of the kind of realities that the first Congress in writing these amendments had to consider. So I'll give you my understanding. The laws of our land will not change tomorrow because I'm offering my opinion. The first Congress and the state legislatures that ratified the Constitution, in my opinion, they had no opinion on firearms. They weren't trying to assert right to firearms. They weren't trying to restrict it as far as individuals were concerned. Remember, the Second Amendment begins with that qualifying clause that Justice Scalia so elegantly disposed of. Uh, it You can read that Second Amendment as not actually applying to individuals. It applies to states. They did not consider limiting or providing a right to individuals to have firearms. It just wasn't on their agenda. It'd be like saying, the people of the United States may not carry knives that are more than 3 inches in length. It's not something they would have done.
We have
They understand.
another, oh,
Go ahead.
we have
Go
another
ahead.
question. It says, I'd like to return to the issue of well-regulated. Isn't the various militia groups that bear arms in violation of the Constitution because they are not well regulated?
I think you're referring to these quote unquote militias in recent years. Um, they're clubs. They're just clubs. They're social groups. They have no authority under state constitutions or under the law, as far as I know. It may vary from state to state, but they're basically a club. They get together, they do their maneuvers or whatever, their exercises. They carry firearms, which, according to the law, they're allowed to have. So, no, I don't think they're in violation of anything. I frankly think they're a little silly, but that's my opinion.
And someone
Uh,
else chimed in, and also the very real threat of foreign powers.
Well, if there's foreign powers, we have the states are under the Constitution are allowed to defend themselves initially without any kind of consultation with the national government. They can defend themselves against outside forces until the national government has time to respond. And when they do, they're going to nationalize. These states are then going to be fighting under an American flag and not under a state flag. But the states were always given the right to protect themselves.
Okay, and we have a question. I actually think you might have addressed this, but in any case, one thing that wasn't mentioned regarding regulation of arms was that even if the government had laws on it, could the federal government really enforce it, especially on the frontier?
Yeah, it's just never mind the frontier. I mean, we can't enforce it in our cities and suburbs today. I mean, it's not enforceable as something that's part of fundamental law. Now, if you want to enforce these things, if you want to restrict them, then you use statute law at the federal and state level, probably not at the municipal level. But it's really at the state level that you might have regulations regarding the safe use and storage of firearms. But the problem is those things, those state laws come under attack all the time. Um, so anyway, as I've mentioned before, they're concerned about suppressing slave revolts, rent riots. They're trying to support settlement of Western lands. You know, Virginia, the Carolinas, and Georgia, up until ratification of the Constitution, had claims to Western lands. Virginia had Kentucky, which ended up becoming a district before it became a state. The Carolinas had what? Tennessee. Um, Georgia had Alabama, you know, going out towards the Mississippi River. So these areas were being settled. They were frontier. And not only could you not prevent those people from having guns, but everybody would acknowledge that they needed them. And again, that point someone made earlier, was defend against the national government's attempts to impose its will on individual states, which, by the way, the federal government has done in recent decades, particularly in regards to civil rights, nationalizing the national guards of certain states to ensure that African American students had access to state institutions. So the implications of my analysis, outside the states' right to defend themselves, the Constitution is effectively mute on individual ownership of firearms. In my opinion, the Constitution has nothing to say on individual rights of ownership of weapons. The Second Amendment does not define who the people are. And there are certain extreme folks, extreme supporters, as they would call themselves, of the Second Amendment, who would say that's right, anybody should be able to have a firearm. But realistically, even back then, would we allow slaves to have firearms? Would we allow felons to have firearms, including those who are inside prison? Women, children, non-citizens? I mean, the people is too vague. It is constitutionally too vague. And then finally, it guarantee even if we see it as guaranteeing an individual's unqualified right to bear arms, and my argument is it doesn't. It's guaranteeing the state's right to be able to arm militias. But even if it supports an individual's unqualified right to arms, it has nothing to say about the right to possess ammunition. And some folks, I'm sure a lot of folks would consider that kind of extreme. But if you take a textualist approach and an originalist approach to the Second Amendment, that's an important uh, omission in that statement. They left out ammunition. Okay, let's move on to the others because I'm sure we're burning through time here. Uh, Third Amendment, no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. This is something I covered in our previous series on the Declaration of Independence because the British government was imposing British soldiers on private property in the 1760s and 1770s, and that was one of the causes of the American Revolution. It is, however, like the Second Amendment, really short. These guys, I mean, what, they run out of paper or something? They could have lengthened these and been a little more specific. I make the point that there's a split infinitive there. No soldier shall, and they have this clause in there, and then be quartered. It should be no soldier in time of peace shall be quartered. And it seems pedantic. It seems like, oh, he's playing the school marm here. But this was written by really smart folks in the first Congress and then reviewed by eventually 13 separate legislatures. Nobody caught this mistake. And in the phrase "nor in time of war," what does that mean? According to the Constitution, only Congress can declare war. So, um, does that mean if we've got some other hostilities going or domestic upheavals that soldiers can't be quartered? It's vague. Fourth Amendment, protection from unreasonable searches and seizures. This is something that's also addressed in the 14th Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This has become an issue lately, largely because of uh, enforcement of immigration laws, that the administrative warrants have been used rather than judicial warrants. And there's a lot of folks that say that's a violation of the Fourth Amendment. You can't use an administrative warrant, something written out by your boss, to bust into somebody's house and arrest them and seize property. And there has to be probable cause. There has to be evidence to suggest that a crime has been committed, and then somebody has to take an oath for which they're held legally responsible when they're requesting that warrant. In the 14th Amendment, we have immunities and privileges, due process, and equal protection. All of that incorporates the Fourth and Fifth Amendments into the 14th Amendment. So these words apply also to state governments. Uh, and what I talked about last year, beginning of last year, the Declaration of Independence series, the Revenue Act of 1767. This is a case where the British government was authorizing basically bureaucrats to enter only in daytime. They couldn't, supposedly they couldn't do it at night, but in daytime they could enter any building and arrest people, uh, secure private property, even though they don't have what we would consider a proper warrant. They could use it, the warrants they were using, like the warrants they're using, administrative warrants they use now. They don't specify who can actually exercise that warrant, which individuals are subject to that warrant, what property specifically or potential evidence is the subject of that warrant. So it has implications for today. Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous crime. We don't know what an infamous crime is, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. So the Fifth Amendment does not apply. We have other laws that apply, but it does not apply essentially to the military or in an obsolete way, a militia when there's an emergency. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. We all know this. You can't be tried twice by the same crime, although the federal government can try and fail to prosecute, but the state government can still potentially prosecute for that same crime. Nor shall be compelled in any criminal case to be a witness against himself, nor to be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. And again, this is incorporated into the 14th Amendment, um, which which holds the state to the same standard. So you need a grand jury indictment unless it's a military exception. And those are governed by in Article 1, which enumerate the powers of Congress. So there's some specificity there. Federal government has one go at a prosecution, but again, it doesn't preclude state prosecution for the same crime if that person in allegedly violating a federal law also violated a state law. The state cannot prosecute a person for violating a federal law. That's the job of the federal government, but it can prosecute somebody who, at the same time, is breaking a state law. It protects us against self-incrimination, guarantees due process, that is, all that a lot of that's laid out in statute law, and just compensation, which is usually considered market value for whatever property the government takes from you. Sixth Amendment, rights of accused persons in criminal cases. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Uh, an issue that's came up a few years back with certain individuals finding every possible legal means of delaying court proceedings. There is a question of here is that a right to speedy trial. Arguments have been made that it's not just the accused who should enjoy that right to a speedy and public trial. The community also has a right to the speedy and public trial of an accused because the person who allegedly committed a crime committed against us as a community. And we also have a right to see that resolved as quickly, as judiciously as possible. So in this right, speedy trial clause, public trial, no secret trials, an impartial jury. I imagine most of you served on jury duty at some point or another, so you have some sense of that. The vicinage clause, which is you need to be tried pretty much in the jurisdiction in which the crime allegedly occurred. Some crimes don't occur in a particular jurisdiction. For instance, wire fraud, which would be a federal crime. It crosses across state lines, and that becomes then a federal crime. And it's up to federal law as to where you would actually be tried, presumably in the federal district in which it occurred. I don't know. You have to be told not only that you're being accused, but what you're being accused of. You have the right to confront and question the witnesses against you. Um, you have you can't be compelled to testify against yourself, and you have the right to counsel, which I'm sure you've all seen enough police procedural television shows to know about the Miranda rights, which actually came along much later, late 1960s, I think.
Jim, I just want to give you a heads up that we have 5 minutes left.
Okay, well, we have three amendments left. Okay, in suits of common law where the value and controversy shall exceed $20, obviously, $20 is nothing nowadays. They didn't count for inflation. So it's an odd threshold. It made sense at the time, but obviously it doesn't really apply. You can waive your right to a jury trial in favor of a bench trial, which is wherein the judge is the jury. No fact tried by a jury shall be otherwise re-examined. This is real important. I talked about it when I talked about Article 3. The Supreme Court, in most cases, serves as an appellate court. They don't question the facts. Those have been established by a lower court, and they cannot re-examine them. Excessive bail, fines, and punishments. Excessive bail should not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Wow. What's excessive? What's cruel punishment? What's unusual punishment? The Constitution doesn't say. Obviously, capital punishment still happens. There's still people who are executed, but it's far more rare than it used to be because it's not considered usual. It's considered excessive. It's considered by many as cruel. And my question is, why couldn't they have elaborated on something like this? This is the Eighth Amendment, and it's one lousy sentence long. And there are no principles behind it that allow us to adapt it to changing circumstances. Article 9, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This is something that people like Alexander Hamilton were fighting for. They're saying, why are we enumerating these things? Um, the original Constitution doesn't give the government power to do these things in the first place. Why do we need to call them out as separate rights? Because they could be construed as limiting rights. And this is the statement here. For why declare that things shall not be done which there is no power to do? Why, for instance, should it be said that the liberty of the press shall not be restrained when no power is given by which restrictions may be imposed? And then Edmund Pendleton in a letter. Again, is there not danger in the enumeration of rights? Maybe not. In the progress of things, discover some great and important which we do not now think of. There the principle may be turned upon us, and what is not reserved said to be granted. So, for example, the Supreme Court said specifically in a recent ruling that there is no right to an abortion. Well, there's not one that's actually written out in the Constitution, but does that mean that that right does not exist? Amendment 8 says, if it doesn't specify, you shouldn't assume that that right does not exist. And then the 10th Amendment is powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. This is problematic because it assumes that all these delegated powers are well defined, and they're not. And it also it keeps it kind of vague. It's like the state or to the people. Well, which is it? And if it's both, how do we decide between them? And so finally, let's sort of sum this up. Constitution regarded as an owner's manual. It originally governed the national government. We have three so-called co-equal branches, but two of those branches have nothing to do with the amendment process. So clearly, Article 1 is a little more important. There are lots of vague parts of the Constitution, uh, partly because they were confronting issues they hadn't addressed before, like what the hell is a president? Article 3 on the judiciary is incredibly vague. It really leaves it up to Congress, which means Congress can decide what courts exist and which courts will no longer exist, hardly co-equal. Divided sovereignty between national and state governments. We're all citizens of both a national government and of the state in which we live. The process for amending the Constitution was designed in recognition of changing conditions, but as we all know, it's exceedingly hard to change the Constitution. It does establish the supremacy of the Constitution over state law. It provides us a means of, in terms of ratification, and we have the Bill of Rights, although who the people are is somewhat difficult to ascertain. So to sum up, finally, my particular observations. These guys who put together the Constitution were smart, they were well informed, they argued over these things. Still, it had weaknesses. For one thing, they were all white men of means, and so they didn't necessarily represent the majority of the population at the time. They had different experiences, and their views were certainly colored. Um, Written under duress, I spent a lot of time on this in one of the lectures about, it's just penned up in a building with the windows closed in the middle of summer in Philadelphia, not conducive to comfortable, quiet discussion. It required novel solutions. The president, for instance, that office is completely novel. They had no real guidance there. And they were also constantly worried about whatever we write, will the people ratify it? So that was a major concern for them. So it's an owner's manual, but it's not a perfect one. And so there's a lot to look at. I hope we've covered most of it, but do consider the Constitution, read about it, and consider this final question. Is the U.S. Constitution more than the text of the original document and its 27 amendments? In order to be a living Constitution, I think it has to be more than what's written on the paper, and yet the Supreme Court decides what's written on the paper. That's all I got. We are out of time. I knew it was going to run a little bit long.
Right. Thank you, Dr. Gibb, and thank you to all of you for all the good questions.